On March 26, Baltimore's Francis Scott Key Bridge collapsed into the harbor after a container ship smashed into one of the pylons supporting the structure. At least 6 people have lost their lives. It will cost at least $600 million to rebuild the bridge, and probably a lot more. Both road and water traffic have been delayed, the supply chain has been disrupted, and insurers could face up to $4 billion in damages. But there's one question everyone keeps asking: who's legally responsible? So here's what we know about how the collision unfolded. At about 12:45 a.m., the container ship Dali left the port of Baltimore down the Patapsco River on its way to Sri Lanka. The ship is owned by Grace Owen Private Limited and managed by a company called Synergy Marine Group, both of which are headquartered in Singapore. In the first statement about the collision, Synergy Group said that the ship was, quote, under pilotage with 2 pilots on board. Pilotage of international trade vessels in the United States is regulated by the federal government and by the 24 coastal states. Under Maryland law, quote, each American vessel engaged in foreign trade and each foreign vessel shall employ a licensed pilot to pilot the vessel when it is underway on the navigable waters of the state. That means local pilots have to guide large ships in and out of the harbor because these pilots are experts in the narrow passageways, shallow waters, and traffic patterns. This is not an easy feat given the massive size of these container ships.
You have probably seen them on the bay, huge container ships longer than several football fields, moving heavy equipment like cars and farm machinery.
And you can see in this video what it was like for pilots on their way to board a large ship off of Cape Henry.
Next time I go down the bay, I am going to take Dramamine pills because that little boat gets a little rough down there at the entrance at Cape Henry.
So in the early hours of March 26, 2 harbor pilots had already boarded the Dali, where they prepared to guide the vessel to open water. Morgan McManus, captain of a trading ship, told Fast Company it typically takes 4 pilots to maneuver under a bridge, 3 of who travel with the boat and 1 from the harbor. The ship also has red and green lights to show the pilots the safest place to pass. The ship started its turn toward the Key Bridge at about 12:56 a.m. At 1:25 a.m., the ship reached a speed of about 8 knots, about 9 miles per hour. But 1 minute later, at 1:26, the ship lost power and the crew made a Mayday call. You can see from the video that the ship is almost in total darkness at this time. According to 911 records, a dispatcher said,
there's a ship approaching. It just lost their steering. So until you get that under control, we got to stop all traffic.
Luckily, emergency responders stopped traffic by 1:28 a.m. Once the Mayday call went out to the authorities, the crew tried to deploy an anchor. However, if the ship had lost power steering, it would have been hard for it to come to a full stop anyway. Transportation Secretary Pete Buttigieg said,
the impact of this collision we're talking about is not just as big as a building, it's really as big as a block. 100,000 tons all going into this pier all at once.
Indeed, the Dali was 948 feet long and 157 feet wide. At 1:29 a.m., the boat lost speed and then slammed into a column holding up the bridge, sending a 1,200-foot section of the structure into the river. A highway construction crew was fixing potholes on the bridge when it collapsed. 8 people fell into the water. 2 were rescued, but 6 others were killed. The workers were from Mexico, Guatemala, and El Salvador. It took 4 minutes from the Mayday call for the bridge to partially collapse, and Governor Wes Moore said the bridge was up to code. So in this situation, who's liable for this crash? Well, the first defendant you would look to sue is Dali's owner. If reports are accurate that the ship experienced a sudden power failure, investigators will need to find the root cause. Was there an equipment failure? How come there wasn't a backup power generator? What about the collision avoidance equipment? Was the crew negligent? We don't know the answer to any of these questions yet. However, the ships have many levels of redundancy and warnings to prevent exactly this kind of thing. As Fast Company explains here, ships today are equipped with redundant systems for maintaining steering control, typically including 2 autopilot systems in addition to hand steering controls, as well as alarm systems that can alert crews to complications. But ship owners also have a way of limiting their liability. As we discussed in the OceanGate submarine video, after the 1912 Titanic disaster, surviving family members sought compensation from the White Star Line, but the company used the Limitation Act of 1851 to limit its liability. This law gives ship owners the right to preemptively file a claim in federal court before plaintiffs have a chance to sue them. The owners can also raise the act as an affirmative defense if they're sued in federal court. And the act limits plaintiffs to post-loss value of the vessel and its cargo, basically the value of its pending freight. The purpose of the law is to help ship owners avoid bankruptcy, and it works. If a vessel and cargo are completely lost, the value of the vessel cannot be calculated in the owner's assets. And in 1915, a judge found that White Star Line was not guilty and had no knowledge of the errors that led to the sinking of the Titanic. Since the accident was considered the fault of the Titanic's captain and crew, the company's liability was limited to passenger fares, the amount paid for cargo, and any salvage materials recovered from the wreck. The company settled for $664,000 to be divided in a pro rata share among survivors. And a federal court recently explained that, quote, the animating premise of the Limitation Liability Act is that the owner of a vessel is generally an absentee who entrusts the vessel to the command of a captain whom the owner has limited ability to supervise or control once the vessel is on the sea. When there's an injury, loss of life on a commercial vessel, current law requires the owners to make a deposit with the limitation fund to cover the losses. And in this case, that will only impact seamen and other maritime workers. The Limitation Act doesn't apply to wrongful death claims that arise out of maritime accidents that do not happen on a water vessel. So presumably the deaths of the highway crew would not be impacted by the Limitation Act. However, there is an exception to the Limitation Act. When a vessel owner has privity or knowledge of the negligent acts, the act does not apply. Whether the Limitation Act applies in this situation depends on what happened on the Dali and whether the owner knew about the issues that may have led to the failure. Privity or knowledge can be actual or constructive, and is present where the exercise of reasonable diligence could have prevented the commission of the act. Thus, the key question for limiting liability is not what the corporation's officers and managers actually knew, but what they objectively ought to have known. Courts typically find an owner cannot limit its liability when it fails to implement or monitor established safety procedures, and this is what happened when the USS John McCain collided with a Liberian-flagged oil tanker, leading to the deaths of 10 Navy sailors. In that case, a federal court declined to apply the Limitation Act because the owners of the vessel had been warned about safety and staffing issues and did not take action. And whether the Dali's ownership knew about problems with the Dali will also be important in wrongful death claims brought by the workers' families. U.S. Coast Guard Rear Admiral Shannon Gilreath said that the ship was going to undergo routine engine maintenance before it lost power, but he said authorities were not informed of any problems. Though apparently during a stop at the port of San Antonio in Chile, authorities cited the Dali for problems with its propulsion and auxiliary machinery back in June of 2023. That comes from the shipping information site Equisys. However, we don't know anything else about the alleged problem. The Chilean Navy issued a statement confirming its inspection of the vessel, but indicating only that there was a problem with the pressure gauges of the fuel heaters, which was fixed before the ship left port. The U.S. Coast Guard inspected the ship in September of 2023, but noted no deficiencies. We also know that the Dali's hull was damaged in a 2016 accident. Dutch cargo company Maersk, which handled shipping contracts for the Dali, was cited by OSHA last summer for violating the Seaman Protection Act after it fired a whistleblower, quote, who had complained about safety violations to the U.S. Coast Guard. We don't know if this is related or not. Under the Seaman Protection Act, though, employees cannot face retaliation if they report maritime safety violations to the U.S. Coast Guard or other federal agencies. Now, there's obviously going to be a ton of lawsuits about this bridge. If you or a loved one was in a catastrophic accident like a giant bridge collapse or just your garden variety car crash, my law firm, the Eagle team, can help. We can represent you or help find you the right attorney who can. It's so important to talk to a lawyer right away so you don't lose your chance for a full recovery and maximize your options. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is below. But one thing is for certain, there's going to be a bonanza of claims and cross and counterclaims as well. It looks like the US government will bear the cost of repairing the bridge, but there's also other damages. The cost of cleanup in the harbor, damages to vehicles, payments to the victims' families, and interruption to other businesses. With respect to delays caused by the crash, the ship might be off the hook. For example, Domino Sugar is located right near the bridge and will probably suffer significant shipping delays. However, most business interruption losses will not be recoverable from the Dali's ownership because of the 1927 Supreme Court case called Robbins Dry Dock and Repair Co. versus Flint. In that case, the court said that the plaintiff who suffered only economic loss because of another's negligence could not recover through a tort claim. So Domino Sugar probably can't sue the vessel's owners because there's not a contract between them, and the tort claim is not available. Of course, the ship owner will not be the only defendants in these actions. There are probably many different insurance companies with a stake in this litigation. The ship is insured through Britannia, which is one of the maritime insurance clubs that are under the International Group of P&I Clubs, a consortium that provides maritime liability coverage for 90% of ocean freight and pools liability claims among members. And a reinsurer then backs these maritime insurance companies. A reinsurer is a company which provides financial protection to the insurance companies themselves. It's basically insurance for the insurance. And CNN reported that around 80 different insurers provide around $3 billion in coverage to the Dali's insurers. Barclays said that the total insurance claims could be between $1 and $3 billion. And since the risk is spread to many different companies, experts don't expect a huge spike in maritime insurance rates. Of course, all of these companies will be involved in the litigation. The NTSB and the Singapore shipping authorities are both conducting investigations, and personal injury lawyers are also looking at whether private engineering and construction companies were negligent, and state and federal agencies are also involved. And I'm sure experts will also assess whether there were any problems with the key bridge's design or upkeep. According to the American Road and Transportation Builders Association, more than 1/3 of America's bridges need repair, and the group classified over 43,000 bridges as structurally deficient, though you might expect the American Road and Transportation Builders Association to be a little liberal with what it calls defective, given that they have a vested interest in that. But most bridges were designed to last about 50 years, and the average age of an American bridge is 44 years. And often bridge maintenance gets deferred so that there's a backlog of maintenance and lack of funds to complete necessary repairs. So if there's an issue with the bridge, whose fault is it? Well, first we think about who owns and maintains the bridge. The defendants will include the state and multiple engineering firms. I'm sure all parties will hire expert witnesses to opine on whether the bridge should have been strong enough to withstand the impact. And this will be a complicated analysis. Maryland authorities will argue that since the bridge was up to code, their role in the bridge collapse was minimal to non-existent. Though there seems to be a growing consensus among engineers that nothing could have withstood this particular impact. And there have been some other accidents involving bridges that have led to huge jury verdicts and settlements. A pedestrian bridge at Florida International University collapsed on March 15, 2018, crushing cars and killing 6 people. The NTSB determined that the FIGG bridge engineers made design errors and failed to identify the risks associated with structural cracks in the bridge before it collapsed. And in that case, the Florida Department of Transportation argued that its involvement with the bridge was minimal since the local engineering and construction firms were under contract with the university, not the state. But the plaintiffs discovered evidence that companies involved in the design and construction ignored warnings that the bridge was likely to cause injuries and death. And as a result, the engineering firms settled with the victims for over $102 million in damages. But the Key Bridge collapse is the deadliest incident since the I-35 bridge collapse in Minneapolis in 2007, killing 13 people and injuring 145. That bridge was 40 years old at the time, and although Minneapolis owned and operated the bridge, it contracted with engineering and construction firms to maintain it.
And then it just split apart like a gigantic zipper, and I went forward as the bridge collapsed.
The NTSB concluded that the steel gusset plates joining the bridge's beams together were too thin. And the Minnesota Department of Transportation had a contract with an engineering firm, URS, to evaluate the bridge's structural integrity. The state sued URS for breach of contract and negligence for failing to discover the structural defects. URS filed an indemnity action against Jacobs Engineering, the company that built the original bridge. And Jacobs blamed URS and the state, arguing that the collapse was caused by modifications to the bridge made by URS at the direction of the state. The two companies battled it out in court before settling with the state. However, URS was in much deeper water with the victims' families and wound up settling a wrongful death lawsuit for $52 million. So you can expect to see myriad lawsuits for negligence, breach of contract, wrongful death, contribution, and indemnity for sure. And there's almost certainly going to be an intense battle of experts in litigating these claims. Though one potential roadblock for plaintiffs is proving that the standard of care was breached. Transportation Secretary Buttigieg alluded to this issue in his comments after the crash.
What we do know is a bridge like this one, completed in the 1970s, was simply not made to withstand a direct impact on a critical support pier from a vessel that weighs about 200 million pounds, orders of magnitude bigger than cargo ships that were in service in that region at the time that the bridge was first built.
And that argument has been persuasive in court in the past. In 1983, a 100-foot section of the Mianus River Bridge fell into the river after midnight, killing 3 people and injuring 2 others. Investigators blamed the collapse on 2 corroded pin and hanger assemblies that allowed the section of the bridge to give way. The NTSB said that the state of Connecticut failed to adequately inspect and maintain the bridge to prevent the corrosion of the pin. Connecticut then sued the engineering company for over $20 million, arguing that the engineers breached engineering standards of the period it was built between 1953 and 1955. The state's experts said engineers allowed too much skew angle between the bridge and the deck, resulting in a force that over time pushed the pin and hanger apart. But a jury cleared the engineering firm, finding that the structure did meet the appropriate design standards for the time. So if the Key Bridge's original construction is a contributing factor in the collapse, then plaintiffs might not be able to collect from the original builders and designers if the bridge design was consistent with the industry standards at the time. And just like bridges were designed for a more simple time, so too was the telephone and email, which is probably why I used to get inundated with spam calls and phishing emails. But today's sponsor, Incogni, can help with online privacy. Because Incogni removes your personal data from online data brokers. Data brokers sell your info to the highest bidder, resulting in loss of privacy, phone calls, text, spam, email, and much, much worse. But Incogni will reach out to those data brokers and make them take your personal info down. If those data brokers fight back, which I've actually seen them do, Incogni will take care of that too. This is a great way to cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, we've all Googled ourselves, you can admit it, but there are major people search sites out there that have way more info on you than just your high school football stats. These sites provide in-depth records, including information such as home addresses, contact details, license plate numbers, and financial information. These sites can expose you to a wide range of dangers, from scams and identity theft to online harassment and stalking. But Incogni gets that information down and out of the hands of scammers and identity thieves. All you have to do is give them approval to work on your behalf, and Incogni conducts repeated ongoing removals, because even if a broker removes your data once, they can always collect it again and then resell it. Incogni makes sure that your personal information stays off the market for good. It's fascinating for me to look at my dashboard and see that I'm on hundreds of data brokers' lists. I feel so popular. So I guess it was no surprise why my email box was full of junk and my phone was constantly ringing with scam calls. For example, here's my Incogni dashboard. It shows that these 3 sites potentially had data on me that was rated 10 out of 10 on Incogni's sensitivity scale. These brokers had data include my contacts, financial data, and health data. But it's seriously relieving to watch Incogni get them to delete that info one by one. So if online privacy is important to you, give Incogni a try. Click on the link below or on screen and get 60% off of Incogni when you use the code LegalEagle. Again, all you have to do to get an exclusive 60% off discount is click on the link that's on screen right now or down in the description and use the code LegalEagle. After that, click on this link over here for more LegalEagle, or I'll see you in court.